13. Commercial instruments as the medium of exchange in modern law. The speaker emphasizes a profound yet often overlooked truth: commercial instruments, not currency, are the legal medium of exchange in the post-1933 financial system. Since the removal of the gold standard and the introduction of fiat credit systems, the legal definitions of money have changed dramatically. Under UCC Article 3, money is not required for settlement, only a lawful promise or order to pay. This change created a system where all debts are settled using negotiable instruments such as notes, drafts, bills of exchange, and judgments. These documents function as lawful surrogates for money, and the entire financial system operates on the presumption that obligations are satisfied not through transfer of substance, but through paper instruments backed by signatures, intent, and proper presentment. The legal fiction of money continues to be perpetuated for administrative convenience, but in the eyes of commercial law, performance via endorsed paper instruments carries full legal effect. This is why banks, courts, and governments consistently operate through bills, notices, judgments, and ledger entries. These are all forms of commercial instruments that, when properly tendered, settle the account. Understanding this shift, from commodity-based settlement to performance-based remedy, allows individuals to interface with courts, agencies, and creditors using the same commercial tools these institutions rely on themselves. Footnote. This section explains the legal replacement of money with negotiable instruments in modern commerce, enabling obligations to be fulfilled through endorsed documents rather than currency. 14. The strategic role of recordkeeping in commercial remedy. In the realm of commercial law, documentation is everything. The speaker repeatedly emphasizes that the remedy does not reside solely in the act of endorsement or tender, but in the creation of an enforceable record of performance. This record, whether in the form of court transcripts, affidavits, mailing receipts, or notarized endorsements, becomes the foundation upon which all further commercial enforcement rests. When a negotiable instrument is endorsed and tendered, it is imperative to ensure the act is recorded either in the court's transcript or by third-party witnesses. Courts often resist accepting such instruments or deny their validity, but these actions themselves serve as evidence of dishonor when properly documented. Silence or failure to rebut is legally recognized as acquiescence, and a properly constructed record transforms this silence into commercial liability. The speaker stresses that when a court, agency, or opposing party refuses to accept tender, the presenter must not argue or escalate the matter verbally. Instead, they should remain calm and simply state for the record, "Let the record reflect that I have tendered performance. It has been refused." That phrase, recorded verbatim, can later be used to establish that the obligation was lawfully discharged and dishonored by the other party. Ultimately, commercial remedy is not won through persuasion, it is won through procedural correctness and evidentiary integrity. Footnote. This section emphasizes that success in commercial remedy hinges on maintaining a legally admissible record of tender and dishonor, forming the basis for future enforcement. 15. Silence as consent, leveraging acquiescence in law. One of the most powerful, yet often overlooked, doctrines in both common and commercial law is the principle that silence is acquiescence. When a party is presented with a lawful offer, notice, or demand and fails to respond within the allotted time or statutory period, that silence constitutes legal consent to the terms presented, provided the process was properly executed. The speaker explains that this principle underlies many of the remedies available through UCC processes. For example, if an agency sends a bill, an order to pay, and the recipient fails to conditionally accept and return it with a counterclaim or request for validation, that silence can be construed as commercial dishonor. Likewise, when the individual tenders a qualified and properly endorsed instrument to discharge the claim, and the agency or court refuses to respond or rebut, it enters into tacit agreement that the obligation has been settled. This doctrine is especially relevant in administrative processes, where rebuttal periods are strictly time-bound. A failure to answer an affidavit, accept a conditional offer, or address a formal tender within the time prescribed by law or notice results in estoppel by silence. Once that occurs, the presenter may lawfully declare the matter settled and proceed to enforce remedy through default or lien. The silent party has, in effect, forfeited its standing through inaction. In commerce, this is not just negligence, it is acceptance by conduct. Footnote. This section outlines how silence in response to a lawful offer or tender operates as legal consent under commercial law, enabling enforcement through default and estoppel. 16. Default, judgment, and the enforcement of commercial remedy. Once a party is in dishonor and fails to rebut or cure within the specified timeframe, the presenter is legally entitled to declare default. In commercial law, default is not merely a procedural lapse, it constitutes the beginning of enforceable judgment. The default process converts the tender and its rejection into an actionable commercial claim that can be perfected and recorded as a private judgment. The speaker details the sequential steps. First, a properly endorsed instrument is tendered. Second, the recipient either fails to respond, refuses acceptance, or does not rebut the validity of the instrument. Third, the presenter documents the event in the record, court transcript, affidavit, or certified mail receipt. Fourth, after allowing a cure period, often 10 to 30 days, depending on the notice, the presenter issues a notice of default. This default may then be followed by a certificate of non-response, notice of fault, and, ultimately, an affidavit of commercial lien, all constructed on the original act of dishonor. At this stage, the record becomes the remedy. The dishonor transforms the presenter into a creditor with an enforceable claim, while the defaulting party becomes the liable debtor by operation of law. Such judgments may be enforced privately or filed into a court of record to gain public recognition. Enforcement tools include liens, levies, offsets, or assignment of claims, all grounded in the administrative record, not judicial decree. Footnote. This section explains how dishonor followed by procedural notice leads to default, creating an enforceable commercial judgment supported by administrative records. 17. Presentment, Protest, and the law of dishonor. Within the framework of UCC Article 3, the concepts of presentment and protest serve as formal mechanisms to document and escalate cases of dishonor. Presentment refers to the act of tendering a negotiable instrument for acceptance or payment, usually to the drawee, maker, or enforcing party. If the instrument is refused, either expressly or by silence, the law provides a remedy through the process of protest, which is the formal declaration that the instrument has been dishonored. The speaker explains that in commercial law, presentment must be clear, timely, and properly recorded. It is not necessary for the presenter to demand payment in fiat currency. Rather, the presentation of a properly endorsed draft, bill, or judgment is sufficient to trigger the obligation. Once dishonor occurs, the presenter should not engage in argument but should instead proceed to declare the protest, stating clearly for the record, let the record reflect that this instrument has been lawfully tendered and dishonored. This protest, particularly when supported by affidavits or court transcripts, establishes a commercial injury. Under UCC Section 3 to 505 and related sections, the protest serves as conclusive evidence that the debt remains unresolved due to refusal, not failure, on the part of the presenter. This initiates the legal standing to advance toward default and lien enforcement. Proper use of presentment and protest elevates commercial remedy from theory into enforceable action, anchored not in confrontation, but in procedural authority. Footnote. This section details how presentment and protest serve as legal instruments to declare and prove dishonor, creating a formal record for subsequent enforcement. 18. Administrative remedy versus judicial relief, choosing the forum. A critical distinction in modern legal strategy lies in choosing between administrative remedy and judicial relief. The former operates under the principles of commercial law, particularly UCC Articles 3 and 9, while the latter falls under statutory and procedural codes governed by civil courts. The speaker strongly advises pursuing administrative remedy first, asserting that it provides more control, greater speed, and a lower threshold of proof when the process is executed lawfully. Administrative remedy focuses on private communication, lawful notice, and unrebutted affidavits, where default judgment is obtained through procedural silence. In contrast, judicial relief requires adversarial litigation, burdens of proof, and institutional bias, often favoring entities with legal teams and systemic advantages. When administrative remedy is properly perfected, through conditional acceptance, presentment, dishonor, and notice of default, it can then be memorialized into a public record or judicial filing as a perfected claim. This approach allows individuals to convert private administrative actions into enforceable public judgments without initial reliance on the court system. Courts are then used only as a venue of record, not as a forum of adjudication. The administrative path respects sovereignty, due process, and commercial capacity, turning remedy into a matter of procedure and record, not courtroom persuasion. By mastering administrative remedy, individuals can remain in honor, avoid controversy, and achieve lawful discharge or enforcement with minimal confrontation. Footnote. This section contrasts administrative and judicial processes, highlighting the power of administrative remedy to secure lawful enforcement without initiating adversarial litigation. 19. The function of conditional acceptance in commercial due process. Conditional acceptance is a cornerstone of administrative remedy and lawful due process under commercial law. Rather than denying or ignoring a demand, a conditional acceptance offers agreement upon the satisfaction of specific conditions, most notably, the production of evidence supporting the claim. This keeps the responding party in honor while shifting the burden of proof back to the claimant. The speaker outlines a typical structure. When receiving a bill, citation, or notice demanding payment or performance, one does not reject it outright. Instead, the individual replies with a notice of conditional acceptance upon proof of claim. This preserves good faith, honors the presentment, and lawfully requires the opposing party to validate their authority, claim, or standing. Failure to respond to such conditional acceptance constitutes dishonor, and that dishonor can be documented and used to proceed with a notice of fault and eventual default. By law, unrebutted affidavits stand as truth in commerce, and conditional acceptance provides the lawful framework to invoke this rule. It is not a delay tactic, it is an assertion of commercial due process. Conditional acceptance also prevents controversy, as it avoids disputing the claim directly. Instead, it transforms the situation into a request for clarification, which must be met or the claim collapses under its own insufficiency. This maintains peace, respect, and honor, while initiating a powerful commercial remedy. Footnote. This section explains how conditional acceptance preserves honor, demands proof of claim, and initiates the lawful process of commercial remedy through due process. 20. The creditor role. Reclaiming standing through commercial knowledge. The essence of commercial remedy lies in reclaiming one's legal and commercial standing as the creditor, rather than operating under the presumption of debtor status. The speaker stresses that the public system, courts, banks, agencies, automatically treats individuals as debtors unless and until they demonstrate, through lawful conduct and documentation, that they are the secured party creditor. This transformation occurs through performance. When an individual receives a claim, such as a citation, tax bill, or judgment, responds in honor via conditional acceptance, tenders a properly endorsed negotiable instrument, and the other party dishonors it, the roles shift. The presenter has fulfilled their obligation. The opposing party has failed. At that point, the presenter becomes the creditor in fact, and the other party becomes the debtor in dishonor. What follows is the right to perfect a claim, establish default, issue affidavits, and enforce liens or offsets, all lawful remedies belonging to the creditor. However, this status must be asserted and maintained. It is not conferred by title or assumption, it is earned through precise performance, procedural execution, and proper use of commercial instruments. Understanding and acting from this position changes the dynamic entirely. No longer subject to presumption, the individual operates as a principal in commerce, restoring autonomy, remedy, and lawful control within the private side of the legal system. Footnote. This section describes how lawful commercial performance allows individuals to shift from presumed debtor status to recognized creditor status, enabling them to enforce remedy.